All right, so welcome back. We are going to begin our discussion of criminal law itself. And honestly, this is where students usually begin realizing that criminal law is much more complicated than most people think. Most people grow up with a very simplified understanding of the criminal justice system. Somebody breaks the law, police arrest them, courts punish them, end of story, right? But once you actually start studying criminal law, you realize that nearly every part of that process is layered with, philosophical debates, constitutional concerns, ethical questions, procedural protections, and really just competing ideas about justice itself. And one of the major themes that I want you thinking about throughout this lecture is who gets to decide what behavior becomes criminal. Because criminal law is not simply about punishing, quote unquote, bad people. Criminal law reflects social values and political priorities, historical context, morality, and governmental power. And those things change over time. So as we're going to begin kind of unpacking what criminal law actually is, why punishment exists, where criminal law comes from, and how the constitutional principles shape the criminal justice system. One of the first distinctions that you need to understand is the difference between criminal law and criminal procedure. And that's because people often use those terms interchangeably, even though they're not the same thing. Okay, so criminal law refers to the actual laws that define the prohibited conduct. So in other words, criminal law answers the question, what behavior has society decided should be punishable? Okay. It establishes what conduct is criminal, what elements the government needs to prove in order to make their case, what level of intent is required, what punishment, might apply, and what defenses might also exist for the defendant. So, for example, homicide laws, they define what qualifies as murder, what qualifies as manslaughter, whether intent matters, what penalties, follow conviction. Okay. Now, there's one thing that is often underestimated, and that's how important intent becomes in criminal law. Because the law doesn't simply focus on the outcomes, it focuses on the mental state. So imagine two situations. In the first, you have someone who plans a killing like weeks in advance, right? But in the second one, someone causes maybe an accident while driving recklessly or while texting and driving. Both of those involve a death. But criminal law treats them differently because the level of intent and culpability differs. So that's one reason why the criminal statutes have become extremely detailed. Okay, so the legal system attempts to distinguish between intentional conduct, reckless conduct, negligent conduct, and accidental conduct. And honestly, some of the most difficult criminal law cases involve determining what someone intended, knew, or reasonably should have known. All right. Again, criminal law also establishes defenses. And that's important because criminal law is not simply about proving harm. Sometimes circumstances justify or excuse conduct. For example, an insanity defense, self-defense, if something is being done under duress or necessity, or if there's just a lack of criminal intent. All right. So that means that criminal law often exists in really more like shades of gray rather than simple black and white answers. Now, criminal procedure focuses on something very different. So instead of defining crimes, criminal procedure is going to govern how the government investigates, how they prosecute, and how cases are adjudicated as a criminal case. So if criminal law answers what conduct is criminal, then criminal procedure answers how may the government enforce those laws. All right, and that distinction is foundational. Criminal procedure includes questions like when can the police stop someone? When can officers conduct searches? What qualifies as probable cause? When's a warrant required? When must someone be given their Miranda warnings? What evidence can be admitted at trial? This is where people will often become frustrated with procedural protections because they are very technical, period. Okay. And people will say things like, well, if they committed the crime, why should the procedure matter? And let me tell you something. There are plenty of times that people are like, in the court of public opinion, and it's strong, they'll say things like, well, we know they did it, so why'd they plead not guilty? Again, we've got nuances here that need to be taken into consideration, which might be defenses, it might be something procedural. Whatever it is, it's allowed, right? I can't stress this enough. The government doesn't give passes, so the government doesn't get passes. But procedure does matter because unchecked governmental power does become very dangerous. All right. And the Constitution was written by people who had a very deep distrust for this concentrated, authority. They had the founding fathers, they had experienced things like government intrusion, military occupation, abuses of power, arbitrary searches, all of those things. So constitutional criminal procedure exists to limit the government's authority and to protect that individual liberty. And honestly, it's one of the biggest, tensions within or one of the biggest tensions within criminal justice is trying to balance, public safety against like constitutional freedom, because that tension appears repeatedly throughout the criminal procedure laws. Now, I went over this a little bit in the previous lecture, so I'm not going to, beat a dead horse on this one. But one of the oldest and most important questions is why does society, punish people? And again, it's typically, the most obvious answer people want to give, and that's because someone broke the law. But again, we have the punishment theory that's way more complicated than that. Okay. So societies develop these criminal justice systems based on differing beliefs, and it's regarding things like accountability and public safety and, morality, deterrence, justice, all of those things. Okay. And one of the oldest is retribution. And that's based on the idea that punishment is deserved. So if someone commits a wrong and society responds with punishment, it's because wrongdoing morally requires consequences. Okay. It's referred to as the just deserts. All right. But I want you to notice something important about this. Retribution is not necessarily focused on changing future behavior. It's only focusing on that moral accountability. All right. So the punishment itself is considered justified because the offender earned it through wrongful conduct. And honestly, you can see, that retribution style thinking constantly in public conversations about crimes. Like after serious crimes, people will sit there and talk about, well, what punishment do they deserve? That language is reflecting that retribution theory philosophy. Another major philosophy is utilitarianism, and this focuses less on moral vengeance and more on societal benefit. So, under the utilitarian theory, punishment is justified if it creates the greatest good for the greatest number of people. All right, so that approach supports goals like deterrence, rehabilitation, incapacitation, and crime reduction. So specific deterrence focuses on like discouraging future offending by a particular offender. And this theory assumes punishment becomes unpleasant enough that the offender is going to avoid repeating the conduct. The general deterrence focuses on society more broadly. So punishment becomes an example that is intended to discourage others from committing similar acts, right? Now, this does assume that individuals make rational decisions, weighing things like risk and consequences and rewards. But many critics have pointed out that a lot of crimes occur impulsively and emotionally, under addiction, or during like severe psychological distress. And honestly, that criticism matters because human behavior is not always going to be rational. All right. And that makes punishment theory really kind of complicated in practice. Incapacitation, just to reiterate from last lecture, but it's going to, focus primarily on preventing offenders from committing additional crimes. And the theory is relatively straightforward. If someone is confined or restrained, they cannot commit crimes against the public during that period. So that would be like through incarceration or house arrest or electronic monitoring, or in some cases where they've been executed. All right. So politically, incapacitation often feels more concrete and immediate. All right. People might disagree about rehabilitation or deterrence, but incapacitation visibly removes offenders from public spaces. All right. But it does raise major questions. And that is like, how long should the confinement last? Should nonviolent offenders receive a lengthy incarceration? What happens to them after release? Does incarceration reduce long-term crime? Those questions become central to modern debates regarding mass incarceration in the United States. And supporters will argue that incarceration protects society. But critics argue that excessive incarceration does things like damages communities. It increases poverty. It contributes to recidivism, and it disproportionately affects marginalized communities. And honestly, no matter where you sit on your end, opinion on this matter, both sides do raise some interesting concerns. But that's one of those things that you really have to do a lot of, I guess, digging and soul searching in the process. Rehabilitation is going to approach criminal justice from a very different perspective. And instead of focusing primarily on punishment, it's going to focus on changing behavior. And the underlying assumption is that at least some criminal conduct results from issues such as addiction and trauma and poverty, a lack of education, mental illness, unstable environments, or limited opportunities. So, under rehabilitation theory, punishment alone, it might not solve the underlying causes of criminal behavior. Instead, systems attempt to provide things like counseling and treatment and vocational training and other, educational opportunities, therapy, or, behavioral intervention. And the hope is that individuals can successfully reintegrate into society and avoid future offending. Okay, so rehabilitation, it became especially influential during portions of the 20th century, where a lot of reformers believed that criminal behavior could be corrected through social intervention. So prisons started introducing things like substance abuse treatment, educational programs, mental health services, and vocational programs. But the theory was that if criminal conduct was connected to social conditions or personal struggles, then improving those conditions could reduce future crime, right? But rehabilitation has also always generated a lot of controversy. So critics have argued that some offenders remain dangerous. Some programs fail. Some systems have become too lenient, right? But others argue that rehabilitation efforts often fail because systems are severely underfunded and overcrowded. And honestly, I think that criticism has merit, especially as we've moved into an era where we have privatized prison systems. Okay. And it's very difficult to rehabilitate individuals effectively in systems that lack staffing, treatment resources, mental health care, an educational infrastructure, and even community support after the person gets released. And one major issue connected to rehabilitation is recidivism. And recidivism refers to repeat offending. And honestly, one of the biggest modern criminal justice debates involves whether incarceration without any sort of meaningful rehabilitation actually increases long-term criminal behavior rather than reducing it. So these are, again, more complicated issues without just simple answers. Now, another important distinction involves the difference between retribution and restitution. So, retribution focuses on punishment as moral accountability. Restitution focuses on repairing harm. All right, so retribution reflects society's condemnation of wrongdoing. The legal system punishes the offenders because the conduct violated societal rules and caused harm, period. Okay. Now, one interesting idea, though, connected to retribution is that organized punishment, these systems, they help prevent vigilantism. All right. And this occurs when individuals attempt to take justice into their own hands rather than relying on the legal system. Now, historically, societies lack structured legal systems, or that lack them, they often experience cycles of revenge and retaliation. So the criminal justice system attempts to centralize punishment within lawful governmental authority instead of personal vengeance. Restitution, though, is different. It focuses specifically on compensating victims for actual losses that are caused by criminal conduct. The examples might be like medical expenses or stolen money or property damage or counseling costs or, maybe financial losses if there was some sort of fraud, involved or something like that. And people often assume that criminal cases, only involve like incarceration or fines that are paid to the government. But a lot of them actually also involve court ordered financial compensation to the victims. And honestly, that reflects kind of growing recognition that criminal conduct affects real people in very real ways. Because victims can experience, emotional trauma and physical injury as a given, but what about any kind of long-term instability from what they've experienced or financial hardship? So restitution is at least attempting partially to address those harms. So one of the most interesting developments in criminal justice involves restorative justice. And restorative justice asks a very fundamentally different question than traditional punishment systems. So instead of asking what punishment does the offender deserve, restorative justice asks how can the harm caused by the crime be repaired? All right, so this approach focuses heavily on things like healing and accountability and community involvement and restoration. All right. So traditional criminal justice systems often center around like state authority and punishment and offender accountability. All right. The restorative justice shifts attention toward the victims and the families and the communities and repairing relationships where possible. So in some restorative justice programs, victims will meet with offenders. Families will participate in discussions. You'll have apologies that will occur. You might have a restitution agreement that's developed. And community service may be incorporated into some sort of resolution plan. Okay? Now, some are sometimes they mistakenly assume that restorative justice means kind of letting somebody off easy. And that's not necessarily true because restorative justice usually still involves incarceration, supervision, restitution, counseling, and just overall structured accountability. But the philosophy emphasizes repairing harm rather than focusing exclusively on punishment. And honestly, restorative justice has become increasingly popular because many people question whether traditional incarceration alone actually heals communities or reduces even future harm. All right. Now, obviously, restorative justice is not appropriate in every situation. Where there's offenses that involve things like severe violence, coercion, trauma, maybe even ongoing danger of some sort, where restorative, approaches may be inappropriate or emotionally harmful, they should not be used. All right. But the rise of restorative justice does reflect a more broad societal conversation regarding things like rehabilitation, incarceration, victims' needs, and even alternatives to traditional punishment systems. Now, one of the most important things that you need to understand is that criminal law does not come from a single source. Instead, it develops through interactions among legislatures and courts and constitutions and administrative agencies and local governments, all of those things. Okay. And I know that this surprises a lot of people because people just assume, well, the laws come from Congress. But legal authority is much more layered than that. So most modern criminal law comes from legislatures through the statutory law. And at the federal level, Congress is what creates the federal criminal statutes. At the state level, it would be, of course, the state legislatures that are creating it. But courts do help to shape criminal law significantly through interpretation. Then you have administrative agencies who create regulations that carrying, they carry legal force in certain areas. And then you have constitutions that also limit what governments can criminalize or how criminal laws may be enforced. And this creates kind of a complex legal hierarchy. So understanding where law comes from is foundational because different sources of law carry different levels of authority. One of the oldest sources of criminal law is common law. And that originated in England and developed gradually through judicial decisions over time. So instead of legislatures writing detailed statutes covering every possible issue, judges resolved disputes case by case. Okay. So over time, those decisions involved creating legal principles that were recognized across the courts. And that's often called the judge-made law. Now, one of the most important concepts connected to common law is stare decisis, which means let the decision stand. All right, so stare decisis means that courts generally follow precedent that's established by prior decisions involving similar legal issues. All right, so imagine if judges completely reinvented legal interpretation every single time a case was heard, right? The legal system would be incredibly unpredictable. But precedent creates some consistency and stability and hopefully some fairness when it comes to legal interpretation. All right. And it doesn't mean that precedent never changes because courts absolutely do overturn prior decisions all the time. We just saw this with, Roe v. Wade and all of that. But generally, prior judicial decisions strongly influence future rulings. All right. Many of the criminal law principles originally developed through common law traditions, including things like murder classifications and self-defense doctrines and conspiracy rules and various, criminal defenses. So even where statutes now govern these areas, there is a common law history that still shapes our legal interpretation for today. So while common law has played a massive role historically speaking, most modern criminal law operates through statutory law, which are the written laws that are enacted by the legislature. At the federal level it's Congress, and at state level it is the state Congress or state legislatures. Those statutes are going to define things like crimes and punishments and sentencing ranges and defenses and procedural requirements. And honestly, criminal statutes have become incredibly detailed because lawmakers attempt to account for the endless amount of factual situations and levels of culpability. So, for example, there is a legal distinction between theft, robbery, burglary, armed robbery, aggravated robbery, and carjacking. Okay, so to someone outside of the legal system, they may all sound like, oh, somebody's stealing, but criminal law categorizes conduct very specifically because did they use force? Because force matters. Do they have a weapon? Because a weapon matters. Location matters. The intent matters. And the risk of harm matters. All right. On the local level, you can have local governments that can create ordinances, which are created by the counties or the municipalities. That is going to cover things like curfew laws, your traffic regulations, noise restrictions, building codes, things like that. The ordinances, though, cannot be in conflict with any higher forms of law. So, like, a city ordinance can't override a federal statute or a state constitution. Okay, this is what I'm talking about with the hierarchy within the legal system. And at the top is the Constitution. And honestly, constitutional law shapes criminal justice far more than people probably really understand. It doesn't define every crime directly, but it places massive restrictions on governmental authority. So, for example, constitutional protections are going to affect things like, interrogations, searches and seizures, due process. Can you confront your witnesses? Even things like protection against cruel and unusual punishment. All right. So constitutional law essentially establishes rules that the government has to follow when trying to enforce criminal law. And that matters because criminal prosecution involves a massive amount of governmental power. All right, so the state possesses things like, the law enforcement authority and investigative resources and, prosecutorial power and the ability to deprive people of liberty. And the constitutional protections exist to try and limit abuse of that power. Now, one thing that is often misunderstood is whether or not constitutional rights generally apply against anything, or, is it just governmental actions? And it does primarily limit it to governmental conduct rather than purely private behavior. So, for example, the Fourth Amendment protects against unreasonable searches and seizures by the government. The Fifth Amendment protects against, governmental deprivation of liberty without due process of law. The Sixth Amendment guarantees procedural rights during, criminal prosecutions. So the distinction becomes extremely important throughout, criminal procedure. Now, one more that I want to add in is the administrative law. And the administrative agencies create regulations that carry the force of law when the legislatures delegate authority to them, and that's done through an enabling act. So some examples would be like, healthcare, transportation, environmental protection, controlled substances, things like that. All right. And a lot of people are often surprised by just how much authority these agencies actually have. But think about it in terms of modern society, which is incredibly complex. Our legislatures cannot realistically draft detailed regulations that govern every technical field themselves. So agencies are created and then they're empowered to further create, rules and regulations within the authority that is granted to them by the legislature. So, for example, the EPA can create pollution regulations. Transportation agencies can create safety requirements. Health agencies can establish, public health standards. And then you have violations of any of those regulations that can come by way of administrative sanctions, civil penalties, and even criminal liability, which all of this creates yet another major constitutional debate on how much authority should unelected agencies possess. Because you have critics on one hand who argue that administrative agencies sometimes exercise a vast amount of power without sufficient, how can I say this, democratic accountability. All right. But supporters will argue that, modern government honestly can't function without having these specialized regulatory agencies. So again, it's just another example of where, criminal law is going to constantly intersect with, those political, debates and more broad constitutional debates as well. Now, in addition to substantive criminal law, which tells us the what is illegal, courts do create the procedural rules that govern, how those legal proceedings operate. That's our procedural law. And court rules generally will address things like your motion practices, your filing deadlines, any kind of discovery requirements, formatting rules, appellate procedure, courtroom administration, things like that, right? And there's a lot of times where people will underestimate how important procedure becomes in legal practice. But these procedural mistakes can dramatically affect legal outcomes. So, for example, missing a deadline for filing might mean that claims are dismissed, or it could prevent an appeal. It could even waive legal arguments, or it could exclude evidence. And honestly, successful legal work often depends just as much on procedural compliance as substantive legal knowledge. And that's one reason why legal professionals become extremely, detailed oriented when it comes to, deadlines and procedural requirements, because in law, the procedure matters tremendously. So one of the most influential developments in modern criminal law was the creation of the Model Penal Code, and it was developed by the American Law Institute. The goal was to modernize and standardize criminal law principles across the states. So remember that under federalism, the states maintain independent criminal codes, and that means that criminal laws can vary significantly depending on the jurisdiction. But the Model Penal Code attempted to give some better consistency when it came to things like criminal intent, culpability, defenses. You've got conspiracy, attempt, and even sentencing principles. The Model Penal Code itself, though, is not automatically law. States had to adopt portions of it before it became legally binding within that particular jurisdiction. And while it has become very influential, with a lot of states adopting portions of it or using it as some sort of, guidance when revising their own statutes, it was not adopted in every state. One of the most important contributions, though, involved clarifying mental states. So instead of using like vague intent language, the Model Penal Code created categories like purposely, knowingly, recklessly, and negligently. And honestly, those distinctions became foundational throughout criminal law analysis, because the mental state often determines things like criminal liability and offense severity and sentencing, and even if there were any defenses that were available. So you'll see that criminal law is, kind of shifts from being about what happened to more about what was, the defendant thinking or intending at the time. Now, one of the most important concepts that I feel like you should understand is that not all laws carry equal authority. So again, the American legal system has this hierarchy of law. And again, at the top is the Constitution. Below that, federal statutes, state constitutions, state statutes, you got regulations, ordinances, and court rules. And they have to all remain consistent with the constitutional requirements. So for example, a state legislature cannot pass a law that violates constitutional protections, in the same way that a local ordinance cannot be in conflict with state law, okay? So courts can invalidate laws that exceed constitutional authority, and it's done through judicial review. And honestly, this hierarchy matters a lot because, legal conflicts, they frequently involve determining which source of law is going to control. And throughout constitutional history, courts repeatedly confronted conflicts involving like federal authority versus state authority and constitutional rights versus legislative action. Governmental power versus individual liberty. And those tensions, again, remain kind of central to criminal justice even today. I'm not going to beat a dead horse on this one or the next one, so you can just pause to read either of these. Again, pause to read if you wish. All right, so before we can fully understand criminal law and constitutional protections, let's talk very briefly about the historical development of the Constitution itself. So, the Constitutional Convention opened in Philadelphia on May 25th, 1787. Now, remember, the founders were attempting something incredibly difficult. They had already experienced problems under the Articles of Confederation, which created a very weak central government. It lacked, sufficient authority to effectively unify the states. But at the same time, the founders, again, were deeply concerned about any kind of concentrated power because of their experiences under British rule. So the Constitution became an attempt to balance governmental authority with protection against tyranny. So the balance still shapes constitutional interpretation today. Now, the Constitution was signed on September 17th, 1787, and it was sent to the states for ratification, which the ratification process itself became very controversial. So you had Federalists who supported the Constitution and favored a strong national government. Then you had Anti-Federalists who feared this centralized authority and worried about individual rights and, them lacking sufficient protection. So those debates eventually contributed to the creation of the Bill of Rights. And Delaware became the very first state to ratify the Constitution in December of 1787. And honestly, constitutional ratification was not simply a legal event. This was this very profound political and philosophical debate regarding, power and liberty and representation and just the country itself. And I know this is like the most condensed history lesson, but just go with it. So on June 21st, 1788, New Hampshire became the ninth state to ratify the Constitution, which was huge. Okay, because 9 ratifications were required for the Constitution to officially take effect. So think about how uncertain this moment must have felt, historically speaking. You have the founders who were attempting to create an entirely new governmental system, and it was unlike anything the world had ever seen before. And there was no guarantee that this experiment would even succeed. So the country was very deeply divided regarding, federal power and state authority and representation and taxation and individual liberty. And honestly, many people believed that the system would fail. Now, Rhode Island became the final state to ratify the Constitution in 1790. But even after ratification, debates about governmental authority and constitutional interpretation, they continued. And it in no way slowed down. And I would go so far as to say that in many ways, the Constitution was intentionally written broadly, okay, because the founders understood that future generations would face situations that they couldn't possibly predict. I know that they definitely could not predict where we are now, but again, that's one of the reasons why, constitutional interpretation, it remains so very important today, because courts can continuously interpret these principles within that changing, social and technological context. I hope that makes sense. Now, one of the most significant developments in constitutional history occurred on December 15th, 1791, with the ratification of the Bill of Rights. Now, remember that many of the Anti-Federalists strongly opposed the Constitution originally because they feared this new federal government had way too much authority without any kind of sufficient protection for individual liberty. So the Bill of Rights were designed to address those concerns. So the first 10 amendments established protections involving speech and religion and assembly and searches and seizures and due process and self-incrimination, the right to counsel, your jury trials, your cruel and unusual punishment. I know I probably left something out. But honestly, criminal procedure law becomes impossible to understand without the Bill of Rights, because many of those constitutional protections govern criminal investigations and prosecutions. They all originate from that point. So, for example, the Fourth Amendment protection against unreasonable searches and seizures. The Fifth Amendment, it protects against the, compelling somebody when it comes to self-incrimination. The Sixth Amendment, it guarantees, rights during criminal prosecutions. Now, another very significant development occurred after the Civil War with the Reconstruction Amendments. The 13th Amendment abolished slavery to an extent in 1865. And I say that because if you read it, it still does leave room for people to be imprisoned and fall within that category. But that's another debate for another class. But honestly, this amendment, though, did kind of transform the constitutional structure of the country. The 14th Amendment was ratified in 1868, and it became the most influential constitutional amendment in American history. And it established due process protections, equal protection, and privileges and immunities protection for anybody. It's not just about, whether or not you're a citizen. And that's incredibly important in criminal procedure because, again, a lot of the constitutional protections that were originally applied only were against the federal government. And this made it so through a process that's known as incorporation. Many of those rights were later applied to the states through the 14th Amendment. So that means that state governments now are also bound to a lot of most, there's only two that's missing, of the constitutional protections involving criminal justice. And honestly, most of the modern constitutional criminal procedure revolves heavily around 14th Amendment interpretation. Now, the 15th Amendment ratified in 1870, it prohibited denying people voting rights based on race, color, and previous condition of servitude. Obviously, history demonstrates constitutional amendments alone do not automatically eliminate discrimination or inequality. Okay. And for decades after Reconstruction, you have discriminatory systems that continued through, like segregation, voter suppression, discriminatory enforcement, and unequal access to justice. And honestly, criminal justice systems themselves were often very deeply connected to those broader, social inequalities. And that historical context matters because criminal law never operates independently from society. Take that in, all right? It just doesn't. And again, it moves and changes with society and how society views things. Now, the final date, May 7th, 1992, this involves the 27th Amendment that's ratified. And what makes that amendment fascinating is that it was originally proposed over 200 years earlier as part of the original proposed amendments. And that amendment limits congressional pay raises from taking effect until after an election occurs. Now, one reason this amendment is interesting is because it demonstrates how constitutional processes can unfold over extremely long periods of time. So the Constitution was intentionally designed to be difficult to change. So that difficulty creates some sort of stability, at least, but it also means that constitutional evolution often occurs very slowly and through, some intense political debate. Now, I went over some of this in the previous lecture, but just to kind of reiterate, we'll talk a little bit about these ethical considerations. Attorneys, prosecutors, judges, law enforcement, they all possess authority that's capable of very profoundly affecting people's lives. And defense attorneys in particular often face a lot of public criticism. Okay. I've seen students even struggle emotionally with the idea of defending individuals accused of serious crimes. And people will ask things like, how can you defend somebody who's, guilty? Or how can you sleep at night? But that question actually misunderstands the role of the defense counsel within the legal system. They are not responsible for determining guilt. That is the role of the court system themselves. They are responsible for ensuring that those constitutional protections are upheld, that procedures are followed, that evidence is properly challenged, and that, governmental power remains limited by law. I told you earlier, the government doesn't get passes or give passes, so the government doesn't get passes. And that's who these people are. And I actually asked this very question to an attorney friend of mine who does criminal law. And he told me that the client's not actually his client. The law is his client. And he just defends the law through the human client. And the way he was talking about, you have to protect all of the rights because then it becomes a very slippery slope. And then it becomes, a world that we don't necessarily want to be a part of. And that was a game changer. I thought that was very profound. But anyhow, the defense attorney, I truly think that they're one of the most important constitutional safeguards within the entire criminal justice system. The legal system depends on adversarial testing, and without an effective defense advocate, you have constitutional rights that will be most likely weakened. You will have wrongful convictions that will increase, and you'll have governmental power that will expand without any kind of meaningful challenge. And defense attorneys are ethically obligated to zealously represent their clients within the bounds of law. But there are some caveats there, right? And it happens to be that within the bounds of law part. Because again, attorneys cannot knowingly present false evidence, and they cannot encourage perjury or engage in any kind of fraud. But they can absolutely challenge, government evidence and police procedure and witness credibility and forensic analysis and constitutional violations. Okay. And honestly, effective defense advocacy protects everyone's rights, not just the rights of the defendant, because constitutional protections do not matter only when someone is innocent. Rights matter, especially when government power is strongest. Okay. It also mentions confidentiality. And that is foundational to any kind of legal representation because clients have to be able to communicate honestly with their counsel. And without those the confidentiality protections, then, meaningful legal representation becomes essentially impossible. So this is the last slide, and I'll make it quick. But I want to talk to you about two major, ethical frameworks. You have the model rules of professional conduct, and then you have the model code of professional responsibility. So these establish your ethical obligations for attorneys regarding things like competence and confidentiality and conflicts of interest, honesty, diligence, communication, and just professional conduct in general. So ethics in criminal justice, though, extends far beyond just attorneys. So you have law enforcement officers who also face you know, a lot of ethical responsibilities as well. And again, unethical conduct by police officers can lead to wrongful convictions, civil liability, you know, suppression of evidence, loss of public trust, things like that. Prosecutors, they also have a lot of extraordinary power and ethical obligations as well. They are not simply expected to win cases. Their ethical duty is to seek justice. Okay. And that includes obligations like disclosing exculpatory evidence under Brady v. Maryland, which I discussed a little bit last lecture. But remember that exculpatory evidence refers to evidence that's favorable to the accused. Okay, so failure to disclose this evidence violates due process and has contributed to a ton of numerous wrongful convictions throughout our history. All right, and honestly, wrongful conviction cases demonstrate why ethics matters so much. Okay, because the criminal justice system really should be depending heavily upon honesty and accountability and professional integrity and constitutional compliance. And without those things, the legitimacy of the entire system begins to completely erode. All right. And that's where I feel like we're at in a lot of cases, because I'm very much a pro, judicial reform individual, not just pro prison, but pro-judicial. But anyhow, so just wrapping this up, I want you to recognize that criminal law is about more than just statutes and punishment. It's about those societal values, those political priorities, you know, the philosophical beliefs, the constitutional principles, and the ongoing debates about justice itself, right? So again, throughout this course, we're going to continue to ask difficult questions. Why do societies criminalize certain behavior? What goals should punishment serve? How much power should the government have? You know, how should constitutional rights limit criminal enforcement? And most importantly, what does justice actually require? Because criminal law is rarely simple, and the deeper you study it, the more you realize legal systems are constantly trying to balance liberty and order and fairness and accountability and power and a whole mess of things. And those tensions essentially shape nearly issue that we're going to discuss moving forward. Okay? And that's it. I will see you in the next lecture. Bye.